Today we're tackling one of the most important parts of real estate, contracts. Whether you're buying your first home or selling an investment property, knowing the basics of contract law can give you a real edge. Stick with me and I'll break it down. All right, let's start with what makes a contract valid. In real estate, for a contract to be legally binding, it needs to have 4 key elements. It must be entered into voluntarily. There must be an agreement between legally competent parties. It has to involve consideration, which is just a fancy word of saying something of value, like money or a promise. And lastly, it has to be for a legal purpose. For example, let's say you're buying a home in Midtown Atlanta. You and the seller sign a purchase agreement that covers the price, the closing date, and other key details. Both of you agree voluntarily, and everything is for the legal purpose, buying and selling property. That's a valid contract. Have you ever signed a contract and wonder if it was truly binding? Share your story in the comments. I'd love to hear it. Did you know that there are 2 main types of contracts in real estate? You've got bilateral and unilateral contracts. Here's the difference. In a bilateral contract, both parties make promises to each other. For example, you agree to buy a home in Buckhead, and the seller agrees to transfer ownership. In a unilateral contract, only one party makes a promise. Think of a lease option agreement, where the landlord promises to sell if the tenant decides to buy. So, if you make an offer on a home in Decatur and the seller accepts, that's a bilateral contract. Both sides have responsibilities. Let's talk about a common phrase you might hear in contracts. Time is of the essence. Basically, this means that deadlines, like submitting earnest money, are super important. If you miss one, it could cost you the whole deal. Now, let's clear up the difference between amendments and addenda. An addendum is something you might add to a contract before it's finalized. For instance, you might attach a home inspection contingency. An amendment is when you make a change to an existing contract. Say you and the seller agree to move the closing date. You'll need an amendment to make it official. Not every contract goes smoothly. If one party doesn't hold up their end, that's called a breach of contract. Here are some ways to handle it. In a unilateral rescission, you walk away. In a mutual rescission, both sides agree to cancel. With liquidated damages, the seller keeps the earnest money. With monetary damages or specific performance, you can take legal action. For example, let's say a buyer in Sandy Springs backs out after all contingencies have been met. The seller might get to keep the earnest money. When you're reviewing multiple offers, remember, look at more than just the price. Pay attention to contingencies and the buyer's financial situation. Use a net proceeds statement to compare offers effectively. Here's a tip. Just because an offer is the first doesn't mean it's the best. Take your time to review all terms carefully. What do you think is more important in an offer? Price or contingencies? Drop your thoughts in the comments. Thanks to the Uniform Electronic Transactions Act, e-signatures are legally binding. Here in Atlanta, we're all about paperless transactions, making the process quicker and smoother for everyone involved. I know contracts can seem complicated, but with the right knowledge, they're one of your best tools for success in real estate. If you have any questions about buying or selling, especially in Atlanta, please feel free to drop them in the comments or message me directly. And don't forget to like, share, and subscribe for more real estate tips.